Imagine signing an important business contract, perhaps for a new partnership or a major service, and then later facing an unexpected disagreement. How that dispute gets resolved can sometimes be predetermined by a single, often overlooked, section of that agreement. It is a critical aspect of contract law that can significantly impact your future legal options. No, a mandatory arbitration clause is not always binding, although they are generally presumed to be enforceable. While these clauses are very common and often upheld by courts, there are specific circumstances under which they can be challenged and invalidated. The core mechanism behind their enforceability in the United States is the Federal Arbitration Act, which generally favors arbitration as a means of dispute resolution. Many state laws also echo this preference, viewing arbitration as an efficient alternative to traditional litigation. However, this strong preference has limits, especially when one party's rights are unfairly prejudiced or the agreement itself was formed under questionable circumstances. For instance, courts will look to see if the clause is clear and conspicuous, and if both parties truly consented to it. Challenges to enforceability often arise from specific legal doctrines. A common ground for invalidation is unconscionability, which refers to a clause that is so overwhelmingly one-sided and unfair that it shocks the conscience of the court. This can include clauses that impose exorbitant fees on one party, severely limit discovery, or prevent access to essential legal remedies. Another factor is a lack of mutual assent, meaning that one party did not truly agree to the clause, perhaps because it was hidden in fine print or was not adequately explained. Clauses attempting to waive certain statutory rights, like those protecting consumers or employees, can also be deemed unenforceable if they violate public policy. If you encounter a mandatory arbitration clause, it is vital to read it carefully and understand its implications before signing. Look for details regarding the specific arbitration rules that will apply, where the arbitration will take place, and who will bear the costs. Be aware that these clauses typically mean you give up your right to a jury trial and often limit your ability to participate in class action lawsuits. Understanding these trade-offs is key to making an informed decision. Understanding the nuances of these clauses provides a significant advantage in commercial dealings. By knowing the potential pitfalls and the grounds for challenge, you can negotiate more effectively or simply walk away from an unfavorable agreement. Always remember that even a widely accepted legal tool like arbitration has boundaries defined by fairness and due process, ensuring that binding agreements are genuinely consensual and equitable for all parties involved.